Hey guys, welcome to part 6 of our video review of the text of the Fair Debt Collection Practices Act. This is John Watts. I'm a consumer protection lawyer in Alabama. And this is part 6. So just as a quick review, part 1 was section 1692. That is why Congress passed the law. And then the subsection A is definitions, and B is when a collector obtains location information. C is how a debt collector communicates in general. And then what we covered in the last video, 1692D, that was part 5 of our series, was about abusive conduct or harassing conduct. Well, now we will look at 1692E. The title is False or Misleading Representations. And this is actually probably the most commonly used section to deal with debt collectors who are breaking the FDCPA, because they almost always will lie. If they're going to break the law, they're going to lie. They're going to be misleading or deceptive. Now, this is a pretty long section, so we'll break this into 2 videos. So let's start with the very first part. And remember, just like in section D, and just like we'll see in section F, the first part of this section E gives us the general rule. And then all the numbered parts after this, the little subsections, are just examples or just illustrations. But they're not the only ways that this can be violated. So let's look at the actual language. It says a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. So it's very broad. It says, look, if you're a debt collector and you're doing something false, you violated the law. If you're doing something deceptive, you violated the law. If you're doing something misleading, you violated the law. And then it will give us a whole bunch of examples, but those examples don't take away from the general rule that anything that's false, deceptive, or misleading violates the FDCPA. And this is important because debt collectors will say, well, we did something and it's not listed in one of those subsections. It doesn't matter. Those are just examples. So, and it even says this, look at the second sentence. Without limiting the general application of the foregoing, what we just talked about, the following conduct is a violation of this section. So number 1 is saying that somehow the debt collector is connected with the federal government or state government. So not something we see very often, at least among legitimate debt collectors. And let me just say this. Broadly speaking, there are legitimate debt collectors and scam debt collectors. The scam debt collectors are the people that, have a prepaid cell phone and they're not a real business and they're just sort of outside the law. Okay, not much we can do about those guys. Okay, a lot of times they're offshore, they're over in India, wherever they are, and they're just going crazy, but there's nothing they can do to you, and there's really very little you can do to them. But the legitimate debt collectors, these guys still break the law all the time, but they're a real business, they're legitimate, we can sue them, we can get money from them. And so this subsection 1, we don't really see that with the legitimate debt collectors. That's more of the scam people. They'll call you and say, hey, I'm with the IRS, I'm with the FBI. And we just don't see that with sort of the real companies. But this number 2 is probably the most common form of 1692E, and that is the false representation of the character, amount, or legal status of any debt. That's really the big one here. And so what does this mean? It's saying if you lie, if you as a debt collector lie about anything related to the debt, you violated this. Well, what could it be? It could be the amount. So you say, hey, John, you owe us $5,000. Really, I owe them $4,000. Well, they lied about the amount. Or they say the status of this debt is we have a judgment against you. And they really don't. Well, that's a lie. Or they say we have a lawsuit against you. They really don't. Well, then that's a lie. The character, it's just what Congress was trying to do here is say, if you lie about anything about the debt, the date of the first delinquency, or the age of the debt, or the type of the debt, just whatever the lie may be, if it's related to this debt, then you have violated this section. Now this, so we got section 2, and A is the big one. This B is saying any services rendered or compensation which may be lawfully received by any debt collector or collection. Pretty rare that comes up, but it could. It could be something about, what the debt collector said, I don't get paid for collecting this debt. And really, they do get compensated. Well, that might be it. But I'll tell you this, in all the years I've been suing debt collectors, we've never used that subsection 2B. So let's look now at the 3 through 6, which will be all we'll cover in this video. Number 3 is lying about being a lawyer. Okay, so if somebody is not a lawyer, but they say, hey, I'm a lawyer, well, then that violates this subsection 3. It could also be that they say, hey, this is, I'm a lawyer and I've personally reviewed your case, and they really haven't. Well, then they lied about it. Okay, that might be under subsection 3, or might be under another subsection. But the point is, if you either directly or indirectly give the impression that this letter or this call is from a law firm and it's really not, then that would be a lie. So let's say somebody calls you and they say, hey, this is Smith & Jones law firm. We're a collection law firm. And there really is a Smith & Jones collection law firm, but this person is, at a collection agency, and they're just sort of renting the name of the law firm. Well, that would be wrong. So anytime somebody says they're a lawyer from a law firm, they better be telling the truth about that, or else they have violated this law. Now, number 4 is something we use a lot related to lawsuits and related to foreclosure. So we just filed a brief yesterday, and we talked in that brief, because it related to a foreclosure, about this section 4. So let's look at this. The representation or implication. So, a lot of times with the FDCPA, people are not necessarily coming directly out and saying, I will come break your legs. Okay, but they might imply something, or they might not directly say, we will garnish you, but they'll say, well, we'll put in the order requiring your bank to pay us money. Well, they may not have used the word garnishment, but same thing. So it's a representation or implication that non-payment of any debt will result in the arrest. Okay, so if they say you're guilty of a crime and we're going to have the sheriff's department pick you up, assuming that's not true, and I've never seen that be true, then that would be a lie. So the arrest or the imprisonment, if you don't pay this, you're going to debtor's prison. Well, that's not true. All right. Look at the next one. This is really where this comes up. Or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless such action is lawful and the debt collector intends to take it. So what does that mean? If they say to you, we're going to garnish your wages, and they cannot do that, because they don't have a judgment against you, and there's a little bit of an exception for federal student loans. Put that aside. The point is, it has to be lawful, whatever they're threatening you, and they have to intend to take the action. So it could be that they say, we're going to garnish you, we're going to foreclose on you, we're going to repo your car, and that's totally lawful, but the debt collector or the creditor that they're operating on behalf of has no intention to do that. Well, then that violates this subsection 4, so 1692E4. Or let's say they fully intend to do it, but they have no legal right. That's what we had in the case yesterday, is this company had no right to foreclose because they had not gone through the proper steps that allow one to foreclose in Alabama. And so they fully intended to foreclose, and they actually said, we are going to foreclose, and they did foreclose. But the point is, they had no legal right to take that. So for the debt collector to threaten you with garnishment, attachment, selling your property, taking your wages, or anybody else's wages, it's got to be lawful, and they have to intend to take that action. Now look at subsection 5, the threat to take any action that legally or cannot legally be taken, or that is not intended to be taken. Now, if you haven't already seen this, you'll quickly realize there's a lot of overlap between these. So built into a lot of these subsections is the idea that if you don't have the right to do it, then that's wrong. Or if you don't intend to do it, it's wrong. Well, subsection 5 just makes that very explicit. The threat to take any action. Well, what does that mean? Well, any means any action that cannot legally be taken or that is not intended to be taken. So what if the debt collector says, we're going to sue you next week if you don't pay this debt? And let's say they have the right to do that. Well, then that would be fine unless they don't have the intent to do it. So we've got a case where somebody said to our client, you have to pay today or the creditor will garnish you starting next week. Well, first of all, there was no lawsuit, so the creditor could not garnish us unless they had a judgment. The only way you get a judgment is file a lawsuit, serve the person, and get a judgment. So that was wrong. And we looked up this creditor. They've never filed lawsuit in Alabama. And so this is something where either the threat could not legally be taken or it was not intended to be taken. So in other words, just an empty threat. So that violates Section 1692E. And then look at number 6. This is not something that we see very often, but from time to time it can come up. The false representation or implication that a sale, referral, or other transfer of interest in a debt shall cause the consumer to, and then we've got two options here, lose a claim or a defense, or be subject to any practice prohibited. So let's kind of imagine this. You get a phone call from a debt collector and they say, you've got to pay today. If you don't, we're selling this to Portfolio Recovery. And once we sell it to Portfolio Recovery, you have no defense to this. And you say, well, wait a minute, this was identity theft. They go, nope. If you don't pay it now, once we sell it, you can't raise the defense of identity theft. Well, that's just a complete lie. And so you could sue them for that. Or they say, once we sell it or assign it to somebody else, you have no statute of limitation defense. You lose that defense once we sell it or assign it. Well, that's not true. And same thing would be with this last sort of subsection, the 6B, that if they say, once we transfer it, then we can arrest you or garnish you or foreclose on you, and that would not be true, well, then it violates this. Now, you'll see the same conduct will violate multiple subsections because truth of the matter is, really, there's just a violation of the FDCPA. This section 1692E is just saying, here's a form of that, and then all these examples are just that, merely examples. But usually, conduct that violates one of these subsections will violate at least one more, and oftentimes many, many more of these. So that's the end of what we'll cover today. The next video tomorrow will run through pretty quickly sections 7 through 19. So that'll be 1692E 7 through 19. Thanks for watching this video. I hope that this is helpful to you. Feel free to subscribe to our channel. Make sure you get the updates on this series. If you ran into this video and you haven't seen the other ones, just look on our channel and they're labeled, I think, Part 1, Part 2, Part 3, Part 4, Part 5, Part 6. So it should be pretty easy to find them. And if you have any questions or comments, let us know. And thanks for watching this, and I'll catch you guys tomorrow. Thanks a lot. Bye-bye.